All right, are you Zakarian Wagner?
No.
And Mr. Wagner, in cause number 24, DCCR 0912, is on probation for tampering or fabricating physical evidence with intent to impair, was placed on probation for a term of 10 years, ordered to go to ISF, and then there was a motion to revoke community supervision filed. We were here previously. Pleas of true were entered in counts 1 through 7.
Actually, Judge, I know
Is that not correct?
That's not what my notes reflect, I believe.
Let me pull up my actual.
Yes, he pled not true to 1 and 2.
And 6 was abandoned.
6 was abandoned, and true to the remaining counts.
Does the state have evidence with regard to those new offenses?
No, Judge.
Okay. Hold on, let me pull it up. Okay, so the pleas of true, the updated report is not correct. The pleas of true were to counts 3, 4, 5, and 7.
That's what my notes
That's
reflect.
correct, Your Honor.
Counts 1 and 2 related to
Indiana.
Indiana cases, and so the state is unable to have evidence with regard to those. Is that correct?
Yes, Your Honor.
So the counts 3 was a void association with anyone previously convicted of a crime. Count 4 was not to leave the state of Texas without prior approval. Count 5 failed to report by mail as directed, and count 7 was fees and being behind in fees, correct?
Yes, Judge.
I have received the updated report, and also I have received jail incident reports. Has everyone had an opportunity to review all of those?
We have,
The state has, Judge.
Are there any additions or corrections to that updated report, other than the pleas of true that I just corrected?
no, Your Honor.
Not from the state.
Okay, Mr. Rojas, you may proceed.
Thank you, Judge. Regarding the incident in Indiana, because he did plead true to leaving the county and being in Indiana, he tells me he had previously lived in Indiana. When he moved down to Texas, he left some things in his apartment in Indiana, clothing, furniture, things like that. He had a roommate here in Texas who was moving to Indiana, and at that point he had an opportunity to go back in Indiana with a truck and bring his things back. He should have asked for permission, Judge. He didn't get permission. He just thought he could make a quick trip to Indiana, get his things, and come back. And that at that point, when he was arrested with another person, he told me the charges against him were never filed. The other person that he was with in Indiana is the one that got charged with those crimes. He's asking to be continued on to probation. And I'll talk about the reporting. He pled true to not reporting to Jefferson County by mail. He tells me he was reporting in person in Orange. He never failed to report in person in Orange. He reported all the times he was supposed to, and I don't see an allegation about that. So I tend to believe that's probably true. He didn't know he had to report to Jefferson County by mail. That's the reason he didn't do it. He tells me that's why he didn't do that. Before he was arrested on the motion, he was working construction, doing guardrails on the highway with the Highways Department. Obviously, he lost that job. He says his mother has a friend who has a wood shop. He can get a job doing that if he were allowed to continue probation. He will be living with his mother in Orange, and so he's asking to be continued on probation. He's still a young man, Judge. He's 20 years old. Obviously, he's certainly old enough to know better than to go out and do these things, especially being on probation. I think he's still young enough to not really understand fully the consequences of what's going to happen to him if he doesn't. I think this has been a wake-up call. He's been in jail since September, I believe. Again, we're asking you to keep him on probation, let this time in jail serve as sanctions, and I don't know what other classes we can give him. He's already been to ISF. But obviously, whatever conditions the court thinks is appropriate, he would follow.
So the person that you were with, that you got in trouble with up in Indiana, has a motion to revoke his probation here in Jefferson County too, correct? Mr. Dyer, Jacathan Dyer?
Do you know about that?
I think that's what he went in for.
What?
I said, I think that's what he went in for as well.
Real quick too, so the allegation of failing to report by mail or online was for May, June, and July. But he had been on probation for several months prior to that. So had he reported online or by mail prior to those dates?
He had been in custody waiting to go to ISF, but he had a pending charge in Harris County. So he had to be transported to Harris County,
Okay.
take care of that, and wait for ISF, then go to ISF.
Okay. And what was that, Harris? I don't remember that.
Unlawful carrying of weapons.
What was the outcome of that case?
They dismissed it because of us sending him to ISF.
Your Honor, just briefly, Judge, the tampering with evidence offense as the defendant pled to is a little misleading in that what he tampered with was a firearm, Judge. When law enforcement encountered this defendant, he had one weapon that they initially discovered, if I recall correctly, and then when they put him in the back of a patrol unit, the patrol car video captures him essentially while handcuffed, dumping another weapon. That weapon was outfitted with what was tantamount to a Glock switch. And I say tantamount to a Glock switch because when ATF tested it, it did not meet all of the requirements to be technically a Glock switch. So he dodged a bullet on, well, no pun intended, dodged a bullet on federal charges, Judge, because we were looking at potential federal charges for the Glock switch. So there's two firearms that he was in possession of. Then he's got the unlawful carrying of a weapon in Houston, albeit eventually dismissed. I'd ask the court to take that into consideration. This defendant has an affinity for firearms, and not only firearms, a Glock switch, Judge, you know the damage these Glock switches could do if that was a fully functional Glock switch, Judge. I'd ask that this court revoke this defendant's probation and send him to prison, Judge. And of course, that amount of prison is in the court's discretion. I do understand that he's a youthful offender, but Judge, you know, these youthful offenders with these guns and Glock switches, they're wreaking havoc in our community. And at a certain point, we need to send a message. I'd ask the court to send a message today, Judge. That's all I have.
Thank you, Mr. Coleman. And Ms. Martinez, thank you for being here. Do you have anything to add that's not already in your updated report?
No, ma'am. It is hard to supervise someone who almost immediately leaves the state without reporting it or requesting permission. We wouldn't have known he was up there if they hadn't called us to tell us that they were in custody of their jail.
I mean, Mr. Wagner, the problem here is that I did with you what I do with a lot of youthful offenders, is we give you that opportunity on probation. I send you to ISF up front so that you have the tools to make better decisions so you can be successful in your probation. So I don't have any other tools because I already did that. And your history, so it's not like you just started getting in trouble once you turned 18 or 19. You've been to TJJD. So you were a youthful offender, so much so that they didn't just put you on probation as a juvenile, you ended up going to TJJD. And it takes a lot, in my opinion, it seems like sometimes, for these minors to be sent there. So you must have really frustrated and done something to end up in juvenile prison. Then you get out and you're doing the same thing, and I don't. So you went to ISF. So April 7th, of 25, you get dropped off when you were discharged from the ISF to probation.
Yeah.
Placed on a mail-in caseload, courtesy supervision was accepted by Orange on May 21st. 2 months later, you're in Indiana in jail in Indiana. With someone who's also in trouble in Jefferson County that probably wasn't supposed to be or didn't have permission to be in Indiana either, I'm guessing. In addition, we have jail incident reports where you prove to me that you don't want to follow anybody's rules. You obviously don't want to follow probations, and you don't want to follow the correctional officers. You are calling names. I can't even say the words. You're gonna slap the F out of the correctional officer. That's great. You're going to everything is just you telling them, I'm gonna do this my way. I'm gonna shower when I wanna shower. I'm gonna wear my clothes how I wanna wear my clothes. I'm gonna tell you to hush when you're talking to me. I'm gonna call you names. Here's one even worse. I'm not gonna say these words. Yeah, all right. I'm gonna find that you entered your pleas of true to counts 3, 4, 5, and 7 freely and voluntarily. This frustrates me so much, Mr. Wagner, because you've given me no chance when I gave you every chance. I have no choice at this point, in my opinion, because you refuse to follow anybody's directions, and that means our community is not safe if you're in it. I'm going to find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering or fabricating physical evidence. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not a plea agreement. You can talk to your attorney about any possible rights to appeal. I need y'all to sign that, and then you'll get your copy. Also, I'm handing you a written admonishment regarding your ineligibility. Go ahead and then I'll read this. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You guys still young, you can make the best of the time that you've got and get out and do better, or you can get out and do worse and be right back in here. So I hope you take advantage of doing better with your life. Go back with the bailiff. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Wade, in cause number 25, DCCR 1648, you're charged with a third-degree felony offense of possession of a prohibited substance in a correctional facility from July 6th of 2024. Your indictment alleges that you were previously convicted of aggravated sexual assault on a child, a first-degree felony, January 22nd of 1998, and after that was final, you were convicted of failure to register as a sex offender, a third-degree felony, November 26th of 2018. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand the possible range of punishment if you're found guilty at trial?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature with Mr. Rojas's and shows that the district attorney's office has made an offer if he would like to enter a plea of guilty for a 15-year term in prison. So that would be to go on counts 1 and 2 only. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
With counts 1 and 2.
So counts 1 and 2, that just makes it a second-degree felony instead of the habitual. So it's the offense you're charged with and one of your priors instead of both of your priors. So that's how we get to 15 instead of that minimum of 25. Make sense? And so do you want to reject that offer and have your case set for trial? All right, we'll get your case set for trial, Mr. Wade.
And, excuse me, can I say?
Uh-huh.
I want to invoke my Sixth Amendment constitutional right,
To,
speedy trial,
you're lucky because in this court, we only have 50 cases waiting on trial. So every case is getting a speedy trial now. So you will get set for trial as quickly as possible and we'll get your case taken care of within a very short amount of time. Now, I wanted to ask you, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release Mr. Rojas. I can appoint another attorney who could begin preparation for trial probably a little quicker. Is that okay with you?
will I have the same right to gather the evidence?
Yeah, of course. Your attorney will get all of the discovery. They'll go over all of that with you, and then we'll get your case set for trial.
And like pictures, like I need him to take some pictures.
Just listen. Let's start with, do you want a different attorney so they can prepare quicker, or do you want to keep Mr. Rojas?
If you're gonna vote,
Any
he
attorney,
told me he was a cop out lawyer.
I can't imagine that Mr. Rojas used those words.
Yeah.
I said she'll give you a lawyer tomorrow. It's just somebody that does, they can get ready faster than you.
You say you're a cop out lawyer that make deals with the DA. I need a lawyer that's gonna help me.
Any of the attorneys who I can appoint in my court are going to represent you to the best of their ability.
Your Honor, if I may, Mr. Rojas has negotiated with me back and forth on this case. We discussed this case at length, both the strengths and the weaknesses in the state's case, just for the record.
I have no doubt that Mr. Rojas has done an excellent job already, but Mr. Wade, I just need to know
Okay.
if I have your permission to release Mr. Rojas and appoint someone else, or do you want to keep Mr. Rojas? Is that
I'm
simple?
gonna take your advice.
It's not advice.
Oh.
Don't be putting words in all of our mouths. I'm not giving you
said
advice.
He was a good lawyer, huh?
I'm saying everyone on this list is a good lawyer. So you can keep Mr. Rojas, or you can get someone else off of the rotation who could probably start your preparing for your trial a little quicker. Mr. Rojas
Okay.
just handles a lot of cases for me.
Okay. Then I need a lawyer that, when I handle my case is
Quicker, because you're asking for a speedy trial and all. Perfect. So I'm going to release Mr. Rojas. I will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes.
You can go back with the bailiff. You didn't get your copy?
No, Judge.
All right, let me hold it. There is a updated revocation of, update.
Do you need a copy of the original also?
Oh, there was an updated one. That's probably why. Okay. Judge, I'm ready to proceed. Okay.
Sure.
Yeah, I'm ready.
This is what? Yes. Here's the defense copy.
There's one that you can have.
Thanks. Yeah, if we could do a recall, if we could recall it.
Absolutely. Give it,
minutes.
I think that's important on this one probably.
Yeah, please.
Just go have a seat, sir. You are Kaisha White. Answer out loud, please. I'm sorry?
Yes.
This is 24 DCCR 2063. And help me out. What are we?
We pled her back in January of last year.
It was a bond forfeiture.
And there's a bond for the punishment hearing. Judge, in speaking with her in the back, she doesn't remember everything that happened last year. I would request a reset to get her evaluated.
Okay.
I don't know, I don't think she agrees with that, but I think that may be the best way to go before we.
Well, I'll obviously you're the one that's speaking with her, and if there's any issue, then we want to make sure that there is everything taken care of before we go forward with any sentencing or withdrawal of plea or anything like that. And so we'll do the order today. Ms. White, there'll be someone to visit with you very shortly, a doctor, to make sure that everything is okay with your understanding of the proceedings that are going on, and then we'll move forward with your case after that. So you can go back with the bailiff. You just go back with the bailiff.
Do I need to file a motion on that, Judge, or?
Good morning, are you Carlos? Right here.
It's Spanish, Your Honor. Would you like me to interpret?
Can you interpret?
I can, yes.
That would be great if you would. Mr. Salinas, for the record, will interpret for Mr. Rodriguez. Sir, are you Carlos Rodriguez?
Yes.
Mr. Rodriguez is charged with indecency with a child by sexual contact. In cause numbers 24 DCCR 1584 and 1585. And Mr. Salinas, what is your announcement at this time?
Not guilty, Your Honor. The motion that I filed, I've had a chance to review the evidence that the state has, including the Garth interviews. Having reviewed that, I have reason to believe that there is potentially exculpatory evidence located at that residence. That residence is for Mr. Laureano. He is the biological father of the complaining witnesses. The relation to my client is that they were his girlfriend's children, not his biological children. His was boyfriend. Mr. Laureano is the biological father. He is the reportee of these of the allegations in general. Having used my investigator already and reviewed the interviews of both complaining witnesses, I reasonably there might be some evidence in his house, in Laureano's house, that might be exculpatory to my client. So I'm asking, Your Honor, if you would allow for an order for my investigator to enter the house, not to take anything, really to take photos and videos at a reasonable hour with that gentleman.
I think what I'll do on this is I will hold making any ruling on this until Mr. Hoffpower is available to take a look at this, take a look at the evidence that you're talking about, and be here to respond.
He did apprise me of what his motion involved and everything. I just don't know any facts on the case enough to really articulate a response. Judge.
I can tell you this is definitely out of the ordinary.
I understand, Your Honor.
Is the allegation, are the allegations in either of the cases that anything
I don't know how free I am
happened?
to speak on when I'm on the record as far as like the evidence itself that I've reviewed. I just don't
Well,
want
I mean, I guess I'm going to have to know, I'm going to want to know a little information.
I understand,
So let's
Your
just
Honor.
wait for Mr. Hoffpower, because if the allegations are that the acts happened at that home, then that might lend to
Yes.
something like that. If it's not, then I'm definitely going to need some more information, and there's no reason for you to give me that without Mr. Hoffpower here.
Understood. And
So-
Your Honor, I do want to point out that we were here, I believe, back in November. Everyone in the case speaks Spanish, so I don't believe Kobe is fluent in Spanish. You can correct me if I'm wrong, either of you. I was told 2 months ago that, the case would be reviewed, that there would be an additional offer. There has, according to the case note, I don't know if it's in his head and he didn't write it, but it's just not
Can
in
you
the
get
case
Mr.
file.
Hoffpower down for just a
I'll see if
minute,
he's free
since
right
Mr.
now,
Salinas is here from out of town? We need to
Thank
make
you.
sure if we were here that
And
long
I did
ago.
email that motion.
Let's
to-
get Mr. Hoffpower down, please.
Okay, thank you.
Yes, sir. And good morning, Ms. Burge. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. Sir, are you Christian Lazo?
Yes.
And Mr. Lazo is charged with aggravated robbery in cause number 25 DCCR 1423, and that's from May 25th of 2025. And Mr. Lewis, it's my understanding that you need a reset to meet further with the Assistant District Attorney and work on the case. Is that correct?
That's correct, Judge. We've met with Mr. Lonzo with Ms. Burge to go over the situation with him. There's definitely some additional investigation that needs to happen before we move forward.
Okay, any issue with that, Mr. Nichols?
No, Your Honor.
Mr. Lazo, I'm going to reset your case so that you can meet with your attorney and then some more and discuss, and then we'll be back at a later date to get an announcement in your case.
Okay.
Thank you. Thank you, Ms. Burge. You can go back with the bailiff.
you.
Sorry you had to wait, I'm so sorry. All right, so what is the announcement at this point?
So I spoke with counsel about stuff that I haven't received a motion like of what it is. He explained to me what
I emailed it.
Okay, when?
It was just recent. I know you were in trial.
Okay. I hadn't reviewed it, but he did explain to me what it was, and my understanding, Judge, is that he wants to get an order from the court, I believe, to take pictures and maybe video of the biological father in this particular case. Not
His home.
His home, not him.
Exactly, right. That's my understanding. Now, I explained to counsel, like, it's not gonna be the state gonna go back and do part of investigation if, an investigator on him would
No,
like to do it.
that's the request, and I know you haven't seen it, but the motion is for his investigator to go into that home.
Right.
Do you have any objection to that?
Your Honor, I think it's up to the court. He's not part of our investigation in any way. I understand if he may think that, that's an
If there's
avenue
any
to take.
potential, I think if there's any potential
Scope.
evidence of exculpatory nature, then I would be,
There's no other way for us to
To
get our
see-
hands on that, Your Honor.
so here's what I'll do. I'm going to grant the motion. Obviously, it is just for pictures and video.
Yes, sir.
It's not to open, move, dig through, look under, things like that. It's just a take pictures, not touching.
Yes, sir.
If there is something based on what's found then that you feel like you need further
Yes.
orders, or hey, we see something we want to get or get tested or whatever it may be, then come to the court and we can deal with that.
Yes, sir.
I would ask that your investigator get with the assistant district or the district attorney's investigator.
Sure.
And that their investigator be allowed to be there, so that, because he also would be, or she would be the person that would
No objection.
facilitate that.
No objection at all.
And get with the biological father, have your investigator get with them,
Yeah.
get with his investigator, have them coordinate, the investigators coordinate when it can happen, and that your investigator can be there for that as well.
Yeah.
Maybe have the homeowner of that home explain the situation and have him sign off on some kind of a waiver. It just seems, he's gonna answer the front door and say, why do these people want to?
No, we're not going to do it that way.
Just do it to your order.
I want your investigator or you to contact him, explain to him that I've allowed this, and explain to him the limited purpose for it. It's just for pictures or video, and that they'll coordinate a time. Your investigator's there to make it more comfortable, somebody he's talked to, then your investigator gets there. So we're not going to have somebody go knock on the door.
Yes, sir.
Y'all have your investigator get in touch with him this week. Your investigator in touch with them, and
Yes.
y'all get this taken care of within the next couple of weeks.
Yes, sir.
And our investigator judge is to be clear, to be present while
Yeah,
this is going on.
absolutely. I think that's to make I want it to happen that way so that the biological father is comfortable
Yes.
with somebody from the state being there as well.
Yes.
And so I think that's probably the cleaner way to do it, okay?
I agree.
So we'll get that done, and then what I'll do is is that all so we'll just reset the case then for a normal reset, and based on that, you guys take some time, please, between now and then. If there's any offers, make sure you extend an offer so that Mr. Salinas can review that with his client before that next court date, okay?
Thank you, Your Honor.
Thank you.
Judge.
You can go back with the bailiff if you could let him know, and I'm going to sign this order.
Thank you, Your Honor.
Good morning, are you Roel Gonzalez?
All right,
I'm sorry?
yes,
Okay. This is 25 DCCR 0226. Mr. Gonzalez is charged with burglary of a building, and I'm going to take judicial notice of the court's file. Mr. Gonzalez was previously found not competent to stand trial, was sent to a facility for competency restoration. I have received a report from the John Dunn Behavioral Science Center dated December 23rd of 2025 with the finding that Mr. Gonzalez is now currently competent to stand trial. Included in that is the report of competency prepared by Dr. Cassandra Hayes. And she also makes the finding that Mr. Gonzalez is currently now competent to stand trial. Let's see. In addition, I received from Dr. Madeline Gabe, a letter indicating medications and treatment that also took place. Her finding and opinion is also that Mr. Gonzalez is now competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, nothing.
Not from the state judge.
And so I will at this time, based on that information and those reports, find that Mr. Gonzalez is now competent to stand trial. What is the announcement?
Judge, I received a report, of course, during the holidays a couple weeks ago. I did go out and visit with Mr. Gonzalez to find that our communication was definitely a lot better than previously. I do need a little additional time. I've talked with the state about whether there's going to be any new offers or anything, which he did convey an offer to me that I need to really sit down with Mr. Gonzalez.
Take some time. Let's just do a normal reset, Mr. Gonzalez. Mr. Lewis will be out there to see you again to go over everything, and then we'll find out what we're going to do with your case at the next court date. Okay, you can go back with the bailiff. Are you Camden Jackson?
Yes, ma'am.
And this is 24 DCCR 0114. Mr. Jackson has recently been, or more recently, been evaluated for competency to stand trial by Dr. Krapon. I've received that report and going to take judicial notice of the court's file. The report from Dr. Krapon is dated December 4th of 2025. He makes the finding in that report that Mr. Jackson is competent to stand trial. Is there any other evidence with regard to competency?
Just not to competency, but there is a concern that I've come to find out, of course, that the entire time Mr. Jackson has been in custody, he has not been on his medication and not been given his medication, and considering some of the medication he's on, I think it explains a lot with the acting out and things, the issues you've been getting from jail.
Right.
So that's a big concern of mine, if we get him medicated and dialed in, so
Okay.
try to move forward.
So what I'm going to do then is make any other evidence with regard to competency.
No, not with regard to competency, Judge. I have reached out to that jailer, I know earlier, due to the proximity of this violation to his actually being granted probation and his behavior in the jail. I did reach out to her. I think she works a different shift than all of us do. I think she's there all night, so I've had a hard time doing that, but I'm happy if the court needs to speak with her. I don't know that we have proceeded on that count one way or another yet.
Well, no, we haven't done anything because we've been doing competency evaluations. And so here's what I'm going to do. I am going to make the finding based on that report that Mr. Jackson is competent. If you'll make a notation and put it on my desk, I'll contact the jail to find out what they need as far as having him evaluated through their medical staff for any medication. And then we'll see if that will help. And then we'll reset it.
And also, Judge, I don't know what kind of help you can provide in this regard, but some of the issues that he has had at the jail with the fighting or things of that nature, or where he may have initially been defending himself and aggressor or things of that nature, but it's a situation where he has asked to be isolated or move away from certain people, and that they've never done it. And so
There's only so many places for all of them is the problem, but I will talk to the jail about that also.
But I understand the biggest issue with him, of course, is the medication.
Okay, I'll work on both of those things after docket. You can go back with the bailiff. Dakota Kuhn. All right, sir, are you Dakota Kuhn? And this is 23 DCCR 0968. Mr. Kuhn has a motion to revoke his probation on probation for attempt to commit assault a family member by impeding breath or circulation. One of the or a couple of the allegations have to do in that motion to revoke with the possession of controlled substance out of Chambers County.
Right.
Mr. Lewis has informed me that they have at this point filed those charges and have them over there, and it's asking for a little bit of time to get with them, get all of that information so we can go forward. So I'm going to reset your case, give him a little bit of time to get everything figured out that he can, get with the district attorney, and then we'll figure out what we're going to do at the next court date. All right, you can go back with the bailiff. Good morning, are you Michael Murillo?
Yes, ma'am.
And Mr. Murillo has 6 cases, cause numbers 25 DCCR 0377, charged with fraudulent use or possession of a credit or debit card, 25 DCCR 0378, burglary of a building, 25 DCCR 1078, burglary of a building, 25 DCCR 1079, burglary of a building, 25 DCCR 1516, burglary of a building, and 25 DCCR 1517, possession of a controlled substance. Mr. Lewis, what is the announcement?
Judge, this defendant here was one that I don't know if he was on bond, but he entered a rehab facility and then turned himself in once he was released from there. Recently, we completed a program. I did reach out to Mr. Hoffmeyer about this, trying to get a resolution, see if we can come to some type of resolution. Mr. Nichols did give me an offer this morning in regards to that, and I talked to Mr. Murillo about it. We wanted to at least have the opportunity to go over some of that stuff from the facility and other things that he did while on bond with Mr. Hoffmeyer.
All right, so Mr. Murillo, I'm going to reset your case, just a normal reset, to give Mr. Lewis time to get all that information, get it to the assistant district attorney, and we'll get an announcement at the next court date. You can go back with the bailiff. I don't know what to do with that. We can have Dr. Holmes try. All right, are you D'Antonio Riggs? And Mr. Riggs is charged with aggravated robbery and cause number 25 DCCR 0975. We had Mr. Riggs evaluated for competency to stand trial. I'm going to take judicial notice of the court's file. It includes the report from Dr. Grapon, which is dated October of 2025. And I'm not sure if I haven't already made this finding. I feel like I would have had a court date since then, but it is and does have the finding in it that Mr. Riggs is competent to stand trial. Is there any other evidence with regard to competency?
Judge, just that I still have some concerns in regards to that matter, especially after speaking with his family on multiple occasions about their interactions with him. When I talk with him, it definitely gives me concerns about moving forward with how we proceed with this matter. I know he's been evaluated before. I would like for someone else to take a look, if that's possible.
Okay. So if you're still having trouble communicating and understanding, the only thing I can do is at this point have someone else take a look. A few months have passed since this was done. There is a history, it appears, with Spinal Tap as well as hospitalizations at Fannin and in Houston. So obviously there's some history. So I will reset the case. We'll do an order and request an additional evaluation to see if anything's changed since that last one, since it was October, and we'll get Dr. Hamza to take a look at them and see where we are at that point.
Okay.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Thank you. Good morning. Are you Joshua Smith? Mr. Smith, you're charged with fraudulent use or possession of identifying items 50 or more in cause number 25 DCCR 1439. And Mr. Lewis, what is the announcement?
Judge, after speaking with Mr. Smith and with my client, there is some questions in regards to his criminal history that I think we need to clear up.
Okay.
So I know exactly where we stand on his criminal history moving forward. I think that could affect what the offer, what we possibly on the counter could be looking at.
All right, so I'll just do one normal reset to give you some time to get all that taken care of. Mr. Smith, I'm sure Mr. Lewis will be out there to explain all of that to you. We'll get an announcement at the next court date. You can go back with the bailiff.
Judge, just so the court is aware, if I may, before we begin, with the court's permission, we'd like to proceed on count one. This offer was made in the context of, it's my understanding from the defendant and Mr. Lewis that his parole officer has gone out and visited him in a TDCJ conviction in this case, which is what we have offered, rather than the 1244 that he requested, will revoke his parole, and so he will have to serve considerably more time on that parole revocation than this amount of time. We're just wanting to put this in place to move the case and allow parole to go ahead and move on their issues.
Okay. I mean, and it's a third, so it couldn't have been unless a 1244 wouldn't have been.
Well, we
an
would have
option.
had to make a big stretch. so-
Yeah. Okay. All right. And so will Mr. Vincent waive the formal reading of the indictment?
He does, Judge.
And sir, are you Troy Vincent Jr.?
Yes, ma'am.
And Mr. Vincent, in cause number 25 DCCR 0384, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from February 11th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vincent is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty in count 1 of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Good morning. Are you Trevon Alexander?
Yes, ma'am. Good morning.
Good. And Ms. Perazo, will your client waive the formal reading of the indictment?
Easily, Your Honor. That's not for this, that's.
Mr. Alexander, in cause number 25 DCCR 0831, you're charged with a first-degree felony offense of murder from May 13th of 2025, and how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazo?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am. She explained it.
Okay, good. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Understood.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the first-degree felony offense of murder sentence you in accordance with your agreement to a term of 30 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also have handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Peraza. All right, good luck to you, sir. You can go back with the bailiff. Let's see, Logan Eaglin, Mr. Peraza.
Yes, Your Honor.
Good morning, you're Logan Eaglin.
Yes, ma'am.
Mr. Eaglin, in cause number 25, DCCR 0897, and we've gone over this before, but I'm going to go over it, make sure we're all on the same page and you understand everything. In that case, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, March 1st of 2013 in 2 different cases of burglary habitation on that date. And then on September 3rd of 2015, you were also convicted of prohibited substance or possession of a prohibited substance in a correctional facility. What that means is if you go to trial and you're found guilty in this case, and those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count 1 only, just the aggravated assault case, with a cap of 20 years as your punishment, which means you would be leaving your punishment up to me. I can give you 20 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right.
In Judge Raquel West's courtroom, one young defendant stood before the bench hoping for another chance. At just 20 years old, he had already received probation and rehabilitation opportunities designed to help him rebuild his life. But instead of following the court's conditions, he admitted to violating multiple probation rules, including leaving Texas without permission, associating with convicted offenders, and failing to report as required. Prosecutors also revealed troubling details involving firearms and repeated misconduct while in custody. After reviewing the evidence, Judge West explained that she had already given him every opportunity to change. She concluded that the safety of the community had to come first and revoked his probation, sentencing him to 6 years in prison. Her final message was clear. Second chances are valuable, but they only matter when someone chooses to use them wisely.